Good afternoon, Judge Windell. How are you? Fine, thanks. I see that we are both dressed in black.
Yes, I saw that.
We were supposed to interview you 2 hours ago already. We do apologize for keeping you waiting.
No, that's no problem. Thank you, CJ.
Thank you for your understanding. Shall we go then? Are you ready?
Yes,
Okay. You have 2 law degrees at BURIS from Northwest University and an LLB from UNISA.
that's correct.
Okay. Uh, you came through the ranks of public service. You started as a prosecutor in 1989 and remained with what you call the NPA now until 1993. So that's 4 years.
Yes,
Then you joined the magistracy.
that is correct.
How long were you a magistrate? 20 years.
20 years,
You were
yes.
a magistrate. So that your term there started in 1993 until 2013, and then you had started acting as a judge from 2011,
Yes, 2011.
which continued until 2013 when you finally got a permanent appointment.
That is correct.
All right. So you have been a judge for how many years? 12 years?
12 years. This
Yeah.
is my 13th year.
And you have acted in this court to which you seek appointment, the Supreme Court of Appeal.
Yes, I've acted 4 terms. I started in 2022. Then I had 2 terms. Then I was invited back in 2023 and then again in this year, 2025.
So how many terms does that make it? 4?
4 terms.
It's a year. It's a long time. And I'll leave that to President Mulemela. I know you mostly from the South African chapter of the International Association of Women Judges. I know how passionate you are about the women's cause and mentoring of young and upcoming lawyers and judges. Are you still involved in that kind of work?
Yes, I've been a mentor to many students this year, students that came to shadow me. I'm part of the Bridget Mabandla mentorship program. I had somebody that I mentored there. I'm also involved in training of aspirant judges, aspirant magistrates. So that has formed part of my duties as a High Court judge. When I was a magistrate, I had more time to go into the community and also mentor their students at the university, as well as going out to the community to inform them of their rights. But unfortunately, being a High Court judge, your time is limited.
Yes.
So that's the way that I'm giving back.
But you have managed to produce good judgments.
Thank you,
With
CJ.
all of that going on. How many have you written in the High Court?
Well, I've had the same secretary now for 13 years, so she has kept files in her office of my
I saw a
judgments.
staggering figure of 440.
Yes, we actually counted them. So it's a lot of judgment, but it's
Yeah.
because being part of the Gauteng High Court. You know, in one term you will easily pick up between 20, sometimes 20 judgments in the course of 3 weeks. So you learn how you have to work fast and get them done.
Yeah, I admire colleagues in that court. I don't know how you manage. So, any of those judgments reported?
I've counted, I've got 11 reported judgments as far as I could see. I've listed them, I think, some of them in my CV and my questionnaire.
You have. You've written at the SA as well.
Yes, I have. In my 4 terms, I produced 2 judgments per term. 5 of them have been reported. Yes, so I've produced two judgments per term.
You've done significant amount of work in the tax court according to your application papers.
Yes, I've for the first time when I was appointed as a judge, I was I was allocated duties in the tax court. The first time I went there, I was completely overwhelmed. But then I actually found it quite interesting. You know, tax law is one of those areas of the law where you can really go into the nitty-gritty of the act and interpret certain sections. So I actually found that very challenging, but also rewarding. And I produced one judgment in the SCA that dealt with tax matters.
So your experience down below came in very handy, I'm sure.
It did.
All right. You had a lecturing stint earlier on in your career at your alma mater.
Yes, I did. I was involved that was in my 20s and 30s. I was involved at the Northwest University, and I also lectured at the LEAD. What is that? The Legal Education. Can't now remember what it stands for, but I was involved with that for a couple of years.
So that's where your passion for mentoring and all that comes from.
Yes. Sorry, when I get nervous, my nose starts running, so just
take your time. And you don't have to be nervous. You're in good hands.
Thank you, CJ.
All right. I'm going to hand over to the commission to put questions to you, starting with President Mulemela.
Thank you,
CJ.
CJ.
Wish to invade.
Good afternoon, Justice Windell.
Good afternoon, President Mulemela.
How are you?
I'm very well, and you?
I'm well, thank you very much. The CJ has already covered a lot of ground. Just for me to mention that you were here before, and subsequent to that, you had an opportunity to act again at the SCA.
Yes, which I would like to thank you for that opportunity to go back earlier this year, yes. Because I think one of the comments from the DP at that stage was that it felt that I needed more experience in the SCA and was granted that opportunity. Thank you for that.
Yes, and how did you find the working environment in your last stint?
I actually enjoyed it very much this time around. I think for me, I found my place at the SCA. I knew most of the colleagues there. The work environment I felt is so conducive, you know, to actually just sit down and deal with your judgments. Everybody's got the same work ethic. You've got the time to read your papers. So I think this time around, I found it very pleasurable. So thank you for that.
And in terms of your turnaround time for handing down judgments?
Well, the last term I produced my first judgment before I left. After that was within 6 weeks, and my second one I finished just after I left the SCA when I was back at the High Court. That was within 2 months.
Yes, thank you very much. Thank you, Justice Windell.
Thank you very much. Good afternoon, Justice Windell, Judge Windell.
Good afternoon, Minister.
How are you?
I'm very well, and you?
I'm okay. I'm following on the work that you do in terms of mentoring and training and the support that you do for those upcoming, but also having had a window of the work that is done by the International Association of Women Judges earlier this year, its significance, and listening to some of the delegates there, it's quite remarkable that this work is done. Just to go into that area, what do you think should be done to encourage more women to come to the bench, to participate, but also within the sector, because there's quite a lot of issue that raises that you do find them coming out of universities, and some actually make it as juniors, but never survives to reach the point where you are. Being in the space of mentoring and training, what are you pulling or what are you picking up as issues that we as a country need to deal with to be able to ensure that more women do make it to the bench?
I think a lot has been done in the last couple of years. My experience is that when you go to, for example, interlocutory court, unopposed motion court, 90% of the litigants, not the litigants, the counsel that appear in front of me are women. It is more issue when I think one gets to more complicated cases, high profile cases, that one still gets that it is men, mostly men that appear in front of us, and especially white men. So I think to encourage is by giving, being an example, seeing what can be done. I moved through the ranks as a prosecutor, then a magistrate for 20 years. And I think that is what we need to do. We need to be a role model for women and explain to them and show them that it can indeed be done.
Thank you.
Minister, Commissioner Moiman.
Thank you, CJ. Good afternoon, Judge.
Good afternoon, Commissioner.
Thank you. Welcome back. Following your last appearance here in May 2024, one of the judgments that you penned is dealt with the extension of security of tenure.
Yes.
Yes. Now, one of the challenges that we have in our countries is dualism in the property regime.
Yes.
Particularly as it pertains to the communal land occupiers vis-a-vis the urban dwellers. The urban dwellers will enjoy certificate of ownership and security of tenure. And now in relation to the communal land occupiers that find themselves under the institution of traditional leadership, they do not have that. Ownership in terms of the communal land, in terms of the Agricultural Land Act, vests in the Minister of Agriculture. So now, given this judgment, it will be interesting to get a sense from yourselves what could be done in terms of extending the security of tenure to those. I'm sitting next to my chief here, who mainly are the leaders of those communal land occupiers. What could be done in terms of property right clause in the Constitution to even extend the security of tenure and the certificate of ownership to those communal land dwellers?
I can only speak to the judgment that I've penned during the earlier part of this year. That was the judgment of, I think it was Pieterse, that dealt with ESTA specifically. So I've never dealt with the question that you've posed to me now. But if I can venture an answer, I would say that there would be an interplay between customary law and common law. And when we go to the community where that is their norm, that is the way that they are living, that is the customary way of living, one should then apply the customary law to those type of scenarios. I've never thought about what the answer would be. I've not had a case like that. But I would think that customary law would play a very big role when one would assess land rights. What does the community want in those circumstances? Does it comply with the Constitution? So that would be some of the aspects that I would consider. But unfortunately, as I've indicated to you, I've not had the opportunity to really think about it and do some research on that topic.
Thank you, Judge. Thank you, CJ.
Okay. Professor Marumukhai.
Thank you very much, CJ. Good afternoon, Judge Windell.
Good afternoon, Professor Marumukhai.
I'm in a process of trying to find out whether the hopefuls who are wishing to serve this country at the second highest court in the country are aware of the systems and the processes of that court. I'm particularly concerned about applications for leave to appeal and applications for reconsideration, those sort of matters. I'm not really sure if you have thought about this. If you have not, then that's fine. I just want your view on it. It seems to me when I read the rules of that code, it is really not as easy to comply when you want to set up the record. To an extent that it appears to me that the process of making the record, it has been commercialized. In other words, for you to be able to comply, if you get a correspondence in Bloemfontein, they will say, can you please get this company that can compile the record? Because the judges want the record to be in this way. And you might find that the way in which the convention is not necessarily stated in the rules. I'm not sure if it's something that you are aware of, or maybe I'm just raising a non-issue. Is there something that you can comment on?
I think when one deals with, are you talking about petitions specifically?
Yes.
Petitions. Petitions must come in a specific form because one would receive on a Tuesday maybe 2, sometimes even 3 petitions. You have to set everything aside and immediately deal with it. So it's so important that there is some sort of format in which those petitions are placed before you. You can just imagine if every person just file papers as they deem fit. So that's why there is a limit on the papers that needs to be must be filed. There is a limit to the volume of the papers that must be filed, and it must be in a certain format. I mean, you must share the frustration when you sometimes get litigants that do not comply with the rules and they file papers in the way that they seem fit. And it's very difficult then, in that short space of time, to actually get to the point, because that's what you need to do. You need to know this is the application, this is the founding papers, these are the answering papers, there I will find the judgment and the leave to appeal judgment. So there must be some structure in filing the papers. I don't know whether...
No, that is helpful, but I think where I'm getting at is understanding that structure, because it is easier for the usual suspect who litigate in that court to know the convention. But if the convention is not in the rules, and there is no, because usually the president of the court will give some directive as to how, if something is not in the rules, as to how something must be done. So if a record has to look in a particular way, and when you read the rules, it doesn't give direction as to how it should be. So in other words, if you are a small firm from whatever, it's for the first time that you're litigating in that court, you don't know the convention. Yes. So it becomes difficult for you to comply with the convention, not the rules, because the rules are not necessarily as enlightening as to how the record should be. I think that is the concern that I'm raising. But obviously it's not your problem. I'm just highlighting it.
I share your concern. We get a lot of matters on petition where it's unrepresented litigants that also file their own papers. And of course, then you would be more flexible because you know this is an unrepresented litigant. So you would condone basically the non-compliance with the rules. In the end, we need to know what is the position. There must be a judgment. There must be some reason why you want to take this matter on appeal. And I think one would bend the rules a bit when it comes to that, especially when it's somebody that don't litigate in the Supreme Court of Appeal on a regular basis.
Thank you very much, Judge Windell. Thank you, CJ.
Commissioner Mnugaitwa.
Thank you, Chief Justice. Good afternoon, Judge Windell.
Good afternoon, Advocate.
Yes, so I was very keen on your judgment on Peters versus Stemmet, because of my concern that despite having a good constitution, it is producing anti-poor outcomes. But the judgment, I think, shows what can be done with a good constitution. Because when you look at the primary facts of that case, of occupiers that have lived on a property that is neither rural nor urban, and it is somewhere in the middle, they do not enjoy the protections of Esther. But at the same time, they must be evicted under PI.
Yes.
And so they are in the middle of nowhere. But I think what is remarkable with your judgment is that its starting point is not the sort of technical wording of the statute. Its starting point is the purpose behind the statute. The purpose, in fact, that is what appears in the very opening paragraph, that
Yes.
ESTA was intended to extend protection to vulnerable people who otherwise would be without a home or without a place of residence. And you do so even in the context where ownership of the property has changed, and the new owner says, I don't know these people that are living
Yes.
here. And so there is something powerful there about the judicial encroachment into the absolute nature of private property. So I wonder if that is something that we can extend to other areas. And the reason I got interested in it is because there was another case on cattle decided by the Supreme Court of Appeal, which went the opposite direction.
I saw that, yes.
So I wonder whether there is scope here to develop this line of reasoning into other spheres in order to make real the promises in the Constitution.
I'm sure
We can
there
think
would
about
be.
contracts, for instance.
Yes.
We can think about other forms of property other than land.
Yes, I think our whole lives is actually based on contract. Everything that we do every single day, everything is a contract. Going back to the matter in ESTA, we had some vigorous debates about that matter. And at one stage, we had a split decision. But in the end, we managed to get together and we produced one judgment. And I think one needs to, as a judge, give effect to ESTA and the constitutional values entrenched in it. And we have to find ways, because it's easy to say we've got a constitution, but then when you interpret law and you interpret acts, you go strictly to words and you forget about the constitution. You say this is not a constitutional matter. So what makes it easy with ESTA is we know that we have to comply with the constitution, and that it has to be interpreted with the viewpoint of the constitution. So I'm sure if we talk about contracts, we know that the Constitutional Court has had the last word on contract, but I think there was a door left open to say that we haven't had the specific facts yet that might open the door for expanding the issue as far as contracts are concerned. So I do think that it's a duty as a judge to actually remind oneself that constitution must always be at the back of your mind. And any matter that you deal with, you have to see how you can apply the constitution in coming to a just outcome.
One of the funny things, I'm sorry, Chief Justice, I know you've cautioned us against this. One of the odd things is that the appeal in front of you was an appeal against the Land Claims Court, which didn't apply the Constitution.
Yes, and there was a very long judgment from the Land Claims Court. It took some time to actually sift, and yes, it was one of those matters.
Afternoon.
Good afternoon, Ms. Steinberg.
I want to follow up on that. The GCB points out in their evaluation of you that you quietly developed the common law in many areas. And every time you've done so, you've come to the aid of the vulnerable group in that case. And that includes the certification of a class in the silicosis case. And there is the ESTA case. There's also in domestic violence, and you'd harmonized concepts of abuse and harm in a way that can only help victims of domestic abuse. And then again in family law, in the Goss case.
Yes, that was a very interesting one.
It really is, and very challenging one, where the court was asked to evolve the common law to recognize jurisdiction over foreign peregrine, where dictal citations been granted and executed. And again, that comes to the aid of the party in a marriage who could end up dispossessed of property that should be hers or his. So it's really to commend you.
Thank you, Ms. Steinberg.
In the work you're doing in fulfilling the promise of the Constitution.
Thank you. Thank you for that.
Commissioner Hassan?
Thank you, CJ. Judge Windell, I'm over here, Commissioner Hassan.
Good afternoon.
Afternoon. My question is around some element of judicial philosophy, but in particular, your record shows both courage and restraint from the class action work that was done in the Kabwe case, but also in Gala, and obviously, I think it was mentioned, the silicosis cases as well, but also to your precise commercial and tax judgments. The SCA often has to walk a very fine line between consistency and some element sometimes required of innovation. And it must preserve some sort of coherence while advancing the transformation project of the judiciary more broadly. I'm just interested, firstly, to understand what you think or how you understand that balance that's between that consistency and coherence, but of course, innovation transformation.
I think it's a long question. I'm just trying to think about my own path thus far. And I think as a judge, one has a duty to actually interpret the law, but only as far as the papers allow you. So sometimes the papers allow you to go a little bit broader. Like for instance, in the Goss versus Modlin matter, it allowed me to open the way for further development of the common law. And I'm very excited to see what's going to happen to that matter, because before me, that was an exception. But on the other hand, in Nkala, in the silicosis matter, although I agreed with everything, I penned a very short dissent on the transmissibility of damages. And the reason why I did that was because that specific case was not argued before us. It was not argued that transmissibility of damages should be extended to all claims. It was argued that it should be done in class actions, as one can see from Australia and in Canada. So when the majority then decided to develop the common law to also include all claims, even road accident fund claims, I had to step in and say, listen, let's see what is in front of us. Look at the consequences. So I think there's a fine balance. And sometimes, as judges, you've got a pet hate, or you've got something that you've been carrying along for a long time, and you want to change it. But it's like putting a round pin in a square hole. Sometimes you have to wait for the right facts so that you can do justice, and then you can develop the common law. So I think it's a fine line that one has to walk.
Thank you. My next question's regarding some of your tax judgments, in particular the SARS versus AXA case, where you emphasized, clarity, fairness, procedural discipline. But tax law often sits at this intersection of technicalities and constitutional principle. And so my question is, how should our courts ensure that tax adjudication remains both legally certain and substantively just, but particularly where more complex statutory schemes affect fairness to taxpayers and the public purse alike?
The matter that I've penned in AXA versus SARS dealt with an objection. So it was very procedural. So it was about whether one can amend an objection at a later stage. And if you look at the judgment, what I did is to look at the pre-litigation phase compared to the after litigation phase. And because there's no rule that provide for the amendment of the objection, one had to go back to the uniform rules of court and then apply that. Infusing constitutional principles, yes, that is a difficult one. I cannot think in that matter specifically how one would infuse constitutional principles. I think maybe fairness would be something that one would consider. But in that specific matter, it wasn't applicable, and it didn't come up.
The President.
Yes, thank you very much, Chief Justice. I didn't want to interrupt the flow of questions, so I didn't speak after Commissioner Marume Wahai had posed some questions, but I think it's important that I should at this platform just clarify in terms of some of the matters that he touched on in relation to the rules of the SCA and the record and so forth. Just to say that the manner in which the record must be prepared is set out in Rule 8. And we require strict compliance with Rule 8. But as correctly pointed out by Judge Windell, there are exceptions that we make when the parties that are involved are unrepresented litigants. And to the extent that there may be a lacuna in the rules, we issue practice directives. And when we issue practice directives, in each practice directive that is issued, you will see there will be a statement that says that if there are any issues regarding the practical application of what is stated in the practice directive, then members of the profession are free to contact the president to raise it with the president. I know that there is a practice directive that was issued by you, Chief Justice, while you were the president in relation to 17.2F applications. It continues to apply, and so far no issues have been raised by any member of the profession regarding regarding the processes that are laid out in there. And we have meetings with members of the profession from time to time. We had a meeting with external stakeholders during the recess. I think it was in July. And that is the platform where we also allow members of the profession to exhale and bring to our attention any issues that they have in relation to how we do certain things. We gave them our side of the story regarding our observation in relation to non-compliance with the rules, and we gave them the opportunity to also raise issues with us, and so far nothing was raised. So perhaps you could write and inquire about the next stakeholder meeting that we will have. The intention is to have it during the recess. So the next one will probably be in January or February. Thank you, Chief Justice.
Thank you, President. No further questions then. Oh, yes, JP?
Thank you, Chief Justice, and good afternoon, Judge.
Good afternoon, Judge President Laleti.
Yes, thank you. I just want to establish, have you ever experienced any challenges of collegiality at the court, at the SCA, such as intolerance to dissenting or somehow bullying, if there is such a thing, intellectual bullying, if there is such a thing, or any other form of ill treatment by the colleagues there? Thank you.
I personally have not experienced any uncomfortability or intellectual bullying. I've certainly enjoyed my time there, got along with everybody. So I've not had any challenges. Thank you for that.
Commissioner Pillay?
Thank you, Chief Justice. Good afternoon, Judge Windell.
Good afternoon, Ms. Pillay.
Judge Windell, I just wanted to raise with you your judgment in Kabwe, where you reached a very difficult decision, which was to dismiss the application for certification. But you do so in such a thoroughly reasoned manner, which I think is highly commendable. Let me start there.
Thank you.
The one difficulty, not difficulty, but question that I had was around the cost order that you,
I can't remember.
So what you did is that you dismissed the application with costs, but you did so because you said the applicants had obtained insurance to cover the cost.
Yes.
And you said that because neither the applicants nor their lawyers nor their funders would be liable for costs because they had obtained this insurance, you felt that it was appropriate to grant the cost order. The question I had was, in that instance, what would be why would parties then be motivated to get the insurance? If without the insurance, a court would say, well, neither you nor your lawyers nor your funders would have to pay. What would be the incentive for getting insurance?
I regret that I haven't looked at that aspect at all. I know it's coming up at the SCA now in the 4th term. I can just tell you that matter, I would be lying on my back in my backyard and look at the stars at 12 o'clock at night and think, how am I going to do this? It was a very, very difficult judgment, and I remember that the cost was one of the aspects, and I know that there were many reasons why I actually decided to grant cost, because normally one wouldn't, I know. But because we had funders, third-party funders in this matter, and we are talking here about billions of rands, not millions of rands, billions of rands. I can't, unfortunately, Ms. Pillay, I can't remember my reasoning, but I can tell you that I struggled, and I really had to think about that, and I can't remember now what my reasons were. Just thinking out loud, I remember there was lots of money, and because it's not the applicants themselves that are bearing the cost, but the third-party litigators, which actually are making a lot of money out of class actions. That was one of the reasons. I regret that I can't remember, and I can't tell you the reasons now.
I accept that, Judge Windell, and that what you've said now was really what gave me a moment of pause when I was reading your judgment, is because we're entering a space where you have more and more third-party funding looming its head. And in this instance, you said because they had gotten insurance, that was one of the reasons you granted the cost order.
Thank you for reminding me.
But I mean, it says a lot that out of this very long and comprehensive judgment, that's the one issue that stood out, me wanting to raise it. Thank you.
You know, it was like expecting a baby, and I was lying there and thinking, this baby must come out. I can't keep this baby in any longer. But you know, it's such a that was a very difficult matter.
Thank you.
Thank you.
Commissioner Mangen.
Thank you, Chief Justice. Good
evening.
Is it evening already? Yes. Judge Windell, I wanted to ask you a question in relation to the insolvency law. We are living in times where the courts are inundated with litigation, and it's encouraging litigants to mediate disputes.
Yes.
And in the process of mediation, it may so happen that a debtor enters into an agreement with the creditor. Will, in those circumstances, be acceptable to regard the settlement agreement entered into during the mediation process as an act of insolvency in the event that the debtor, for one reason or the other, breaches the settlement agreement?
Well, it will depend on the facts, obviously. So, say, for example, you owe me 10 million rand, and you promise to pay me back at 1 million rand a month, and you fail to do so. And one of the avenues would be then to apply for your sequestration. And obviously, when you've entered into a settlement agreement, even though it was part of the mediation, it's not a privileged document. It will obviously depend on the terms of the settlement. But I can see an example or a case where one would then approach the court and say, this person has acknowledged that he can't pay the debt, that he owes this money, because that would be one of the requirements, and he has now failed to do so. But there are many other factors that would come into play. But I can't see how one would be prohibited from using a settlement agreement. It will obviously, it might be that when one enters that settlement agreement, that you there's provision made for the fact that this would be a privileged document. I'm just now thinking out loud. But I've had matters where people have signed acknowledgement of debts, for example, and then they fail to comply with the acknowledgement of debt. And that very acknowledgement of debt is then used as a reason to approach the insolvency court.
Now, let me leave it at there. The professor will take it up.
See, now my nose starts running again.
Do you really want to answer the question?
I'm done, CJ. But the professor is dying.
Is it absolutely necessary? Will it make any difference? This candidate we've interviewed before and tested. All right. Judge Windell, thank you very much for making the time to join us this evening. And thank you for not giving up on us and coming back again.
Thank you, Judge Meyer, and thank you to all the commissioners. I was almost taking out all the books. I'm just taking my own. Thank you very much.
Thank you.